morning. You can be seated. Owner versus Town of Kennebunkport. That's York 23-265. We are being streamed live on the web, both audio and visual now. And if council would identify themselves by saying their names for the record, together with the party you represent, starting with the appellant.
Good morning, Your Honor. Amy Tchao for the Town of Kennebunkport.
Good morning, Your Honor. Daniel Murphy for 15 Langsford Owner, LLC.
Thank you. And Attorney Tchao, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. I neglected to mention I'm here with my colleague, Mac Walton. May it please the court. The central question in this case is whether a commercial hotel business can transform an 11-unit residential apartment complex located in a predominantly residential neighborhood into a full-fledged hotel or inn operation, while completely sidestepping the zoning and land use requirements in the town's ordinances that govern such commercial lodging uses, simply by seeking short-term rental licenses for all 11 units on the property and claiming that they are residential uses. This case turns on the use of the property within the meaning of the ordinances, and whether the property was an inn or hotel use on the one hand or a residential use on the other. Here, the code enforcement officer found, based on overwhelming and undisputed evidence in the record, that the petitioner was operating a hotel or inn on the property in 2021, and therefore no licenses could be issued for short-term rentals, which under the short-term rental ordinance is specifically defined to exclude hotels, motels, inns, and such uses. I'd like to make 2 points initially, and then I'm happy to answer questions if the court has them. First, in support of affirming the code enforcement officer's decision is the standard of review, which is deferential to the code enforcement officer, whose decision to deny these licenses is the operative municipal decision here. Contrary to petitioner's misstatement of the standard of review, it is the petitioner, the Langsford Kennebunkport, not the town, that bears the burden of persuasion to show that the code enforcement officer's decision was clearly erroneous, an abuse of discretion, or unsupported by the evidence in the record. Secondly, this court has followed this very framework in 2 of its decisions that are directly on point, which the petitioner's counsel in his brief does not even attempt to address or distinguish. And those cases should point this court hotel versus a dwelling, and specifically made the determination that these use distinctions mean that residential uses are distinct from commercial lodging uses. And in finding that an apartment cannot be a hotel, and logically a hotel can also not be an apartment because the definitions mutually exclude the other, the Jordan court found that you cannot be both. Importantly, the Jordan court also found that the characterization of a structure as fitting within a particular use definition in an ordinance is a finding of fact for the administrative decision maker and is accorded to be substantial.
I see the green light's on. Can we start with the facts that led up to this scenario?
Sure.
As I understand it, there was a multiplex unit with 9 units in it.
That's correct.
And I think we agree that the construction of these units were residential dwelling units.
Initially under the former owner, Your Honor, that's correct.
I'm not talking about use now. I was talking about, I'm getting real basic here.
Yes.
They have a bathroom and a kitchen, and a family could live there for a year and never go out. They're residential dwelling units.
Yes, initially this was a multi-unit apartment building, and it was rented to long-term renters.
Right. And then it became at some point condominiums.
Yes, it did.
So if I bought unit number 3, I owned that condo, I could do a short-term rental on that.
You could at the time.
At the time, yeah, I'm talking at the time.
At the time, you could, because there was no short-term rental ordinance. The declaration of condominium at the time did, which was the subject of the condo conversion permit, did limit the uses of the units, even though owned by condominium form, to to not hotel uses, and it specifically prohibited transient uses.
Right,
And
but at that time,
Correct.
I, as the owner of Unit 3, could rent it for a week out of the year.
you, for more than 7 days, yes, Your
More
Honor,
than 7
that's
days. A week or more. So that was the status back then, and then what changed, what changed after that point was all the units were bought, or the multiplex was bought by a corporation. So
Correct.
the corporation became the owner of all of these later to be determined condos. So in theory, are you still with me, that the owner of all those units still had at that point, under the previous to the ordinance, still could have done short-term rentals?
So the owner could have done short-term rentals. It depends on the actual use of the property.
Okay, I'm not
Your Honor.
talking about the, you're going to, next step is the extent of the use. But at least in theory, if the owner of all of them wanted to rent out Unit 8 for 14 days, they could have done it at that point,
This is prior to the short-term rental ordinance coming
prior to the
into effect.
STRO, yes.
Could they have rented to short-term guests?
Okay, now here's what you want to get to. You're going to say, you're going to say, okay, they got all of them, and they were all of a sudden ramped up the use beyond just, a week here, a week there, and that was the tipping point, that at that point going forward, that they could not do that at that level. Is that correct?
That they could not, yes, there was a tipping point based on the actual use of the property and how it was held out. And this court in Morgan versus Townsend has said these factors, such as actual use, pattern of use, and how you hold out the property, can actually transform a residential property, the short-term rentals of a residential property, into a commercial business.
I remember
lot.
Morgan versus Townsend very well.
I know.
So
I know you're right.
you don't need to cover that one for me, but so I'm getting
arguably
actually
that's a restrictive covenant case. I understand the distinction there.
right.
But
As I said, it may have implications for other settings, but that was narrowly construed. But now to the point that I think you really want to get to, and I'm taking too long to get there. At that point, before the STRO, these were legally existing residential units,
Well-
dwelling units.
So, no, Your Honor, in order to determine whether these were legally existing residential dwelling units within the meaning of the STRO, you need to look at the land use ordinance and the short-term rental ordinance together.
You
Because
do,
in-
but how does that get you to use? You keep wanting to focus on how they were in fact being used. But the phrase is legally existing. It's not what the use was prior to the advent of the STR, but what they were legally existing seems to implicate what they were legally classified as.
So, Your Honor, this court has said that in order to interpret an ordinance, you have to look at the overall entire ordinance scheme and to achieve harmonious results. So if you look at the land use ordinance and the short-term rental ordinance together, both of them say that dwellings and dwelling units do not include motels, hotels, and inns. Okay, so if you have a use that is an inn, you need to go get conditional use approval in this zone.
And you
under the
could
land use ordinance.
have brought a notice of violation or done something if the town thought that that was the
Could do,
case.
and that's correct, Your Honor, and the town in this case did put on 15 Langsford owner on notice several times that they were in violation and felt they were being operated as an
But that
inn.
brings me to another problem. So what is the difference between an owner who may have more, let's assume there's more than one unit that they are renting under the short-term rental program. Let's assume they may be two in a building that they're renting. What is the difference between that? Why are not all short-term rentals also at that point if that's all they're doing with it, inns or hotels? Although granted, not all inns or hotels would necessarily fall under the short-term rental because they wouldn't all be full dwelling
Let me
units.
try to explain it this way, Your Honor. The short-term rental ordinance is a licensing ordinance.
I understand
It's
that.
It's only available for the short-term rentals of residential properties. And so the use determination needs to be made in conjunction with the interpretation of the land use ordinance, which says if you're a commercial lodging use, there are certain zones you can't locate in. If you're another commercial lodging use, you have to get planning board's conditional use approval. All the short-term rental ordinance is saying is if you're an inn, it says it specifically in its short-term rental definition.
So
If
what's
you're
the
an
difference
inn-
between, I understand it says that if you're an inn, you have to get an inn, you can't do short-term rentals.
Actually,
What I'm
to-
trying to figure out is, how can you, if somebody says, I've got these 5 units, I want to do short-term rentals, why are they not an inn?
Why are they not an inn? Well,
Yeah.
on these facts, Your Honor, we have a multi-unit, 9-unit apartment building that was transformed into a hotel, advertised as a hotel. This was actually advertised as early as February 2021.
I understand that. My question is in the ordinance. How does it distinguish between what are validly licensed short-term rentals versus what is an inn?
Well, it does distinguish when you read the two together, because the short-term rental ordinance says commercial lodging establishments are exempt from licensure.
But isn't that
Because if
catch
you're
20?
this,
Isn't
if
that
you're-
circular? If it's short-term rental, it's not an inn. If it's an inn, it can't be short-term rentals.
Well,
I
you
mean,
have to, I would
where's the
submit,
line?
Your Honor, that the threshold determination that needs to be made to determine whether you get a license is to determine what the use is first. It's no different than this. If you had a zone that had...
But the definition of a hotel and an inn refers to guest rooms. I mean, these units, 15 Langsford units, are more than guest rooms. I mean, they are independent, self-sufficient places where people can stay, as just as Mead said, sort of indefinitely.
They were units that were coordinated, and they were given coordinated names. They were advertised as a hotel. They were operated as a hotel. They were on a coordinated online booking engine, crow's nest, sea spray. These were all coordinated units that were for rent as part of a hotel that was one of 10 in the Kennebunkport.
Was any
Resort
notice of
Collection.
violation ever issued for illegally operating a hotel in an area where you can't unless you get
The notice of
approval?
violation could have issued. The town did put this property owner on notice that they were illegally operating an inn, and they asked, and actually the Langsford did comply initially.
Let me ask you, just have 30 seconds remaining. Does the STRO, is that a land use ordinance that tells you what you can and can't do?
The SCRO is a licensing ordinance that is intended to be read and must be read in conjunction with the operation of the land use ordinance, or it doesn't make any sense, Your Honor, I would submit. And both of them require you to determine whether you have a commercial lodging use on the one hand or a residential use on the other. And then you can determine whether you can get a license. It's no different than if you had a food truck versus a restaurant. And if you actually used it as a restaurant,
Madam Chief?
you shouldn't be able to get a food truck. I see my
May I
time is
have
up.
leave to inquire past the red light?
Go ahead.
Oh.
I wanted to ask you actually a question that hasn't been raised at all or discussed, but is a matter of concern to me. This is coming up to us on an 80B. I mean, usually we see a notice of violation, an OV issued, it goes to the Board of Review and comes up and all the rest of it. This was simply the fact that a license wouldn't issue. So as you know, 80B doesn't create an independent right of appeal. You have to hook it in under some other theory, and in looking at the APA, it doesn't follow from that. This is an action by a municipal officer. It's not final under the APA. The STRO doesn't have a provision for appeal. Section 30 MRSA, Section 4482B applies only to appeals from municipal review boards. And it's not clear that the CEO is an agency official from whom an appeal can be made. Have you explored this at all as to whether or not this court actually can entertain this appeal? Or is this something new that I'm hitting you with out of the blue?
Have there been any other appeals of this sort in Kennebunkport? Is that the question you're on?
No, what I'm getting at is ordinarily what's being appealed here is basically a lack of action. They didn't give the owner a license, and I can't find an independent statutory basis.
What is the grounds for appealing this under 80B?
The denial of the license, I believe, it is in the ordinance. The appeal is to court.
It's in the
Is it in the
STRO?
ordinance?
I believe it is, Your Honor.
Huh, okay. Must have missed
Perhaps you can, you're going to have a little
I'll have
recess
time on
here.
rebuttal, and I will
So
double-check.
perhaps you can direct us to that on rebuttal.
But I will say that there are licensing ordinances, local licensing ordinances, where the denial or the revocation or suspension of those licenses is appealable.
We understand that, but ADB specifically says there has to be a statute or otherwise appealable by law. So I think that's what we're getting.
All right, we'll let you think about that, and it's a heads
Thank you,
up
Your Honors.
to your opponent.
Madam Chief Justice, members of the court, may it please the court. I'd just like to note at the outset that Unit 2 and Unit 3 have been sold to another party, and those correspond, I believe, with AP 2218 and 19. This is not my appeal, but I just want to make that known. There are 2 other units that are under contract but have not sold yet. But I just wanted to make that may affect the remainder of portions of these appeals. It's a consolidated case. The question presented in this appeal is whether the town CEO erred or abused his discretion when he denied 11 separate short-term rental applications for 11 separate condominium units that are owned by 15 Langsford. At the trial court level, the Superior Court correctly concluded that the town erred as a matter of law because each of the 11 units qualified as legally existing residential dwelling units, we've called those LAIRDU for short, and otherwise satisfied the requirements under the short-term rental ordinance. The Superior Court rejected the town's argument that these licenses should be denied based on the assertion of commercial use as a hotel or inn. Rather, the court correctly determined that the 11 units were LAIRDU based on the town's prior approval for these 11 units during the condominium conversion process in 2020 and other times. These prior approvals make clear that the 11 units are comprised of single-family dwelling units and multiplex dwelling unit. The Superior Court correctly noted that multiplex dwellings are for residential occupancy. It's a residential unit. This includes condominiums. That's express. The same is true for single-family units. They're residential units. These are legally existing residential dwelling units by the town's own hand. They were approved as such. The town's argument rests on an insistence that each of the 11 units together consist or comprise a hotel or inn and cannot be a legally existing residential dwelling unit because of asserted commercial use. However, the definition of commercial use under the town's land use ordinance expressly excludes the rental of residential buildings and/or residential dwelling units. Renting a residential unit in Kennebunkport, Maine is not a commercial use under the land use ordinance. That's under section 240. At the same time, under the short-term rental ordinance, the rental of residential units for compensation is not a disqualifier. It is a condition to meet the short-term rental definition. This means that receiving money for rentals cannot transform residential status into commercial status. I think it's also important to look at the definition of short-term or dwelling unit under the short-term rental ordinance. This definition is one or more rooms arranged for complete independent housekeeping purposes with space for living and sleeping, space for facilities for eating or cooking, and provisions for sanitation. Most hotel rooms do not meet this requirement. The 11 units did meet this requirement.
Counsel, I see that the green light is on, and since the cat is out of the bag now, I'm going to go straight to the issue that Justice Mead ended with. Is there something in the ordinance? What is the basis for the ADB appeal here?
Well, it's
review it has to be provided by law, so that's why I'm trying to.
Yeah. Well, of course, I would love to say that if the short-term rental ordinance is deficient, that it should be overstruck. That because it lacks a method to appeal. But that's just a fundamental item of due process I think we both have thought that ADB is elastic enough to allow for review of municipal action.
Well, ADB certainly is the way in which we review municipal action. However, it says review is available if it is provided by statute or otherwise available by law. ADB itself does not create a right of action. So it has to be available by law. I note that may mean statute, it may mean municipal ordinance, it could be perhaps even one of the great writs, but.
In this case, the ordinance does provide for an appeal.
Does it?
under Rule 80B, page 52 of the appendix, section D, but it seems to be limited to decisions by the Board of Selectmen to suspend or revoke a short-term rental license.
Yeah, and I...
What section was that again, please? What section did you cite?
Yeah, page 52, section 129-8,
Okay.
D.
But is there a provision for the appealability of the either issuance of a license or refusal to issue the license?
Well, that's limited to suspension or revocation of a license. You can appeal that decision. Okay.
Yeah. So I mean, in our complaint, we've raised lots of arguments with respect to deficiencies in the short-term rental ordinance with respect to due process.
We'll return to that. And just to be clear, perhaps we'll ask for supplemental briefing on whether this is cognizable under 80B. And then we can go to the merits right now.
Okay, thank you. Well, I was raising the definition of dwelling unit under the short-term rental ordinance and noting that it has, the definition includes requirement for separate sleeping, cooking, sanitation.
Is the essence of your argument on appeal, which is essentially what the court did below, that this is not a legally existing residential dwelling unit is determined by what the legal classification is, whether it's a dwelling unit in the first place, which it is, and whether it's a legally existing residential unit versus how it may or may not have been used?
Yes, yes, Your Honor.
And the town goes to the use. I mean, they make a good point here. Like, this isn't, Ma and Pa Jones who have a camp on Lake whatever, and they're going to rent it out for a couple weeks in the summer. This is a conglomerate coming into town, buying up a bunch of apartments, and kind of ramping it up to a level that one might suggest wasn't anticipated, and the town and the residents of town are justifiably saying, wait a minute, this is a large turnover, large volume operation that used to be apartments.
I disagree with you, Your Honor. I think you're assuming a lot. That's not in the record. These are 11 different condo units in the town of Kennebunkport. They're used
Is anybody living there?
Well, they're used by the owner in the off-season. They are rented. If you look at the record, it's marked Town 428 to 513. You actually have the rental history.
Yeah.
It's less than a quarter of the year that they're actually rented out. It's generally from June to September. It's a very
that's
short
usually
period of time.
because not lots of people are renting condos in Kennebunkport
Right, exactly.
on, February 4th.
That is true. And there are many people who have second homes who are not occupying their homes, but they own them and they are available and they are used occasionally by the owner for different uses. But this is not some kind of intensive use, and that it has common ownership with a company that has hotels and other accommodations in town does not transform condominium units, which are self-contained,
Well,
into
what
a
would
hotel.
transform, assume, I know that two of them are in a different building, but assume you have, 9 units in one building, they're being used for transient rentals, whether you manage to rent them 52 weeks a year or not, that's what the sole use is. What is the difference between those short-term rentals and an inn?
Well, that's difficult to answer because the definition of hotel and inn under the land use ordinance is so broad that it sweeps up every single short-term rental in the town of Kennebunkport. It just says lodging for money, and the only qualifier is whether it's 10 or more or 9 or less. So I don't know how to make that distinction. There is no distinction under the law in Kennebunkport with respect to that hotel status. But these are all self-contained.
Well, let me ask, I think it's generally recognized that there's a shortage of affordable housing, and some people attribute that in part to the proliferation of short-term rentals. Can we take that sort of social issue to influence our decision about where the dividing line is between an inn and a hotel and a short-term rental as defined in the ordinance? We are bound to construe the terms of the ordinance, but in making that kind of determination about where the dividing line is, can we take into account the realities of the world?
No. If you own the property and you invest money, you're entitled to put it to the use that you think is important. It would be, in my estimation, it would be incredible to have a town say you have to take that condo unit and turn it into something different. So I think that ownership, that bundle of rights, does not allow, there may be a tax best as possible or something of that nature. But I don't know if you're talking about repurposing the condos for providing housing for other purposes.
No,
but-
I'm not talking about repurposing or making anybody do anything. It's just a question of how they are categorized to determine how those units are going to be used.
I don't think that factors into the definition of hotel.
Because if they can't be used for short-term rental, then that means maybe they can be used for housing for year-round people or employees who work locally. I mean, something like that. I mean, there are those sort of social implications and consequences of the scope of the short-term rental ordinance.
Yeah. I'm not sure how to answer that, Your Honor. I do want to drill down on this use issue because the condominium units may be rented for 31 days or more at a time. They may not be rented for 29 days. So this notion that somehow short-term rentals or long-term rentals are akin to a hotel, it's.
Are you talking, when you said that, are you talking about under the language of the condominium declarations, or when you said they can or can't be rented for 29?
No, per the town. We're free to rent for 31 days. We may not rent for 30 days or less. So we do
Under the
rent.
short-term rental ordinance?
Their position is that we're not subject to the short-term rental ordinance.
Okay.
We own these condos, so we can rent them for 31 days at a time.
So what you're referring to with the 29 versus 30 days is what what is the source of that is what I'm trying to find out.
The short-term rental ordinance is for 30 days or less.
Right?
And so if you're beyond that, if you're 31 days, you're outside of that short-term rental license. You don't need a license to
But I
rent
mean,
31
hotels
days.
and inns are generally 30 days or less too.
Correct. Well, I was getting to that definition of dwelling unit under the short-term rental ordinance. I wasn't able to develop it, but we're talking about separate facilities for sleeping, cooking, eating, and sanitation. You can bake a cake in a condo. You can do your laundry, washing and drying. You
There's
don't
no
do that
question
at a
they're
hotel
dwelling
room.
units.
You don't do that at a hotel room.
Is that the last word on whether it's an inn or a hotel, the fact that it does have all these facilities? Can you stand on those facilities alone to say we're not an inn, we're not a hotel because solely of these facts?
Well, I think also you have to look at the application portal. So the manner in which you submit an application to get a short-term rental license, it's automated, it's electronic, and it makes no mention of hotel, inn, commercial use, anything of that nature. It's a rubber stamp. And so...
So you meet the standards, right?
The standards, yeah.
Is there any question you meet the standards?
No.
So getting back to what I think is the central issue in the case is whether or not this was a pre-existing legal use of the premises at the site before the STRO came in?
Yes.
And is the fact, and to put it in the vernacular, they're trying to say you're an inn, and you're saying, no, these are individual units. My question is the fact that your units resemble private residential dwelling units rather than a hotel or an inn, which is typically has just a room. Is that the end of the road? Is that the end of the conversation? The fact that you have residential dwelling units, whereas hotels and inns are different?
That's part of the conversation, and I think meeting the dwelling unit definition under the short-term rental license with separate facilities is important as well, that we meet the standards.
And you're saying they shouldn't be looking at the fact that it's owned by a conglomerate and...
Absolutely not. I mean, people own various interests all over the state. That you have common ownership does nothing to speak to the status of the property itself.
Well, the Jordan case that Ms. Tchao mentioned, that case was a hotel versus apartment building case.
Yes.
And the court looked at evidence about whether, for example, there was a front desk for this proposed development, whether there was going to be like automatic housekeeping and all that sort of thing. I mean, so not just the physical structure of the facility, the proposed development, was under consideration, but the way it was going to be used and managed was relevant. So if there are those kinds of factors that are relevant to a determination about whether something is residential or more transient, I mean, why isn't it proper for the CEO to take off blinders and look at the way the 15 Langsford properties were being marketed and run?
Well, I would say in Jordan, that was a kind of unique case where someone applied for apartment buildings where they were banned, and then reapplied with the same stuff and said, we're a hotel, and then admitted that there was no termination for rental. They essentially said, we have an apartment here. I would note importantly that even in that case, the court found that it's a mixed question of fact and law, the characterization of the structure. It's not just a question of fact. And I've cited to 7 cases in my brief about the legal determination. Whether a proposed use falls within the terms of a zoning ordinance is a question of law for the court. So I want to be clear about the standard review on that. But I would note also under this ordinance, there's no method to actually contest a denial before it happens. And it is assigned to the town's clerk in conjunction with consultation with the CEO.
And that may be why we need to have some subsequent briefing, I'm noting that the time is up, on how the court has jurisdiction. And maybe we'd be interested in hearing why everybody thinks we do.
Okay.
Okay, thank you.
Thank you.
Ms. Tchao? Can I
Your
just
Honor.
say I'm completely mystified in this STRO ordinance about how it seems to be a requirement that you have already been doing it without a license.
So getting back to the question of how these two ordinances operate, petitioner argues that it's the pre-existing legal characterization of what is going on, what has been authorized by the town, that governs whether you issue a license here. And I would submit that if that were the test, then in no case you could just have a use that's frozen in time, authorized by the town, and you would have to ignore how the property is actually being used.
But doesn't the town have a remedy? In other words, if first of all, a property is being used in a manner that is unlawful in that particular zone, the town has a remedy. You can bring a notice of violation. And vice versa, if somebody wants to change what is an authorized use, there may be ways of doing that to change or expand the use, and by whether it's application to the planning board, et cetera.
What the Langsford wants you to do is look at the physical characteristics of what are going on in the building without regard to use. And I would submit to you that the term dwelling unit and dwelling, this is a codified ordinance, and the definition of dwelling in the land use ordinance here actually contemplates uses. It actually is defined as any building or structure or portion thereof contain one or more dwelling units, but not including a motel, hotel, inn, or similar use. So you don't check the issue of how this is actually used and whether it fits
Except
within-
that the ordinance requires that they be engaging in short-term rentals for these dwelling units.
The short-term rental ordinance does also refer to use. It actually refers to use of a legally existing residential dwelling unit for these transient rentals, and expressly includes an in use. So, Your Honor, I would submit to you that in looking at these together, you can't just look at the STRO in a vacuum. You have to look at and the code enforcement officer made factual findings that are overwhelming. And even if this court were to disagree with them, they cannot say that the evidence supports a contrary result here. In this case, the code enforcement officer's decision that this was an inn and therefore not eligible for an STR license that is not available expressly under the STRO.
The definition of hotel in the land use ordinance refers to a building or group of buildings having 10 or more guest rooms in which lodging is offered for compensation. If there's a building with 10 separately owned condo units and all of the unit owners offer short-term rentals, does that convert the building into a hotel?
The condominium issue is not dispositive, Your Honor, I would say. The condominium is simply a form of ownership. It doesn't pertain necessarily, nor is it dispositive on whether a particular use is going on. What you have to actually look on is the facts on the ground. That's exactly what the court in Morgan said. in determining whether a short-term rentals of a residential property actually could be used as a commercial business. It depends on advertising, how you're holding it out, how the actual pattern of use is. I see my time is up.
It
Thank
is.
you, Your Honor.
Thank you, counsel. What I'm going to do, I'll issue an order for some subsequent briefing to ensure, we weren't pressing you too hard on it because I'm not sure anybody had an answer as to what the basis was. But I do note that 80B requires that there be a statute or other, that review be available by statute or otherwise available by law. And so it doesn't create a cause of action. So we're trying to figure out what the basis is. So we'd be interested to hear your thoughts on that. And why don't I issue an order asking for some subsequent additional briefing on it, okay? Thank you. And with that,